We're back after our 7-minute break. Thank you. Tucker wanted to just provide some follow-up real quick, and then we can proceed to a committee discussion. Yeah, thank you, Mr. Chair, and thank you, committee members. I just wanted to provide a little context of where the Department of Public Safety is coming from on the public safety topic generally. Every week, the Department of Public Safety is the policy team, and they meet on Monday mornings and talk about internal policy issues, but also policy issues that come up in the news media, etc. And we do this regularly, and more often, the conversations in those policy meetings turn to the latest case of the week, in which we may be getting a phone call asking for an explanation of how these circumstances have arisen and allowed to persist, or the latest meeting that a local community is having on the topic of public safety. And so it's risen to the level where we think that it's worth bringing the scope of those concerns, the scope of those cases, the scope of those community meetings just to your attention generally, and to kind of tackle, hopefully with you, or offer some potential directions on where some of the issues and hotspots that we see. We were talking about the bail revocation piece. My observation or general judgment is that that's the origin of some of the persistent repeat offenses that we're seeing that's somewhat unique to Vermont. Now, of course, as we're getting into here, the constitutional contours of that are relatively strict. They're limited, so there's not a huge amount of room for the legislature to weigh in there, but there's potentially some that may be worth considering. But the example that I gave, the quintessential example, was the individual who over 1 year had 230 law enforcement encounters, 69 arrests, more than a dozen arrests for violations of conditions release, and 35 active criminal court cases. So that's kind of one example. The problem is that example doesn't appear to be an anomaly. We have around the state examples like this that have triggered these community meetings where there's an expression of a level of frustration about the system's current inability to intervene and stop some of this behavior, despite the significant harm that is inflicted on the community. As we discussed last time with some of that NIBRS numbers with the reports of the offenses, the thefts from motor vehicles in 2018 going from about 1,100 to 2,700 in 2023. That's the type of thing that makes communities gather together to have some of these meetings. The shoplifting for the merchants, going from approximately 1,600 in 2018 to 3,300 in 2023. It's the type of increase that kind of gets on people's radar and really kind of seems to affect some of our own communities. So it seems worthwhile to kind of bring some of these cases to your attention and have kind of conversations and work to see where there's potentially some improvement to be made legislatively, but also within the management of the administration as well, within the programs that we have. I provided you my printout of some of the cases over the last 6 months, from July 1st, 2024 to December 31st of 2024, of some of the specific cases that have remained persistent. Now, Act 138 last year made some headway here, but as I was alluding to last time we met, I think it's left open this question of when someone doesn't voluntarily comply with the new pretrial release program or the new home detention expansion to the pretrial space, then what? It's the question of then what when you don't have that voluntary compliance. That question is just still out there, and it's in the, I think, realm and jurisdiction of this committee to kind of be aware that we don't have necessarily a good answer to that under law. So it might be worth exploring what are some of the avenues to address the then what question. So Senator Rohoski.
Do you have an update on the status of the pretrial supervision pilot?
I don't. I know that DOC is the entity that was getting that off the ground. I was under the impression that it was a beginning in 2025, but that was a discussion at my direction about that. So I think DOC is going to be the entity that is going to have to know most of this.
Yeah, I'll just say to, like the conversation around repeated offenses of shoplifting or, stealing from a car. I mean, I absolutely hear it, when I'm going around the more populated areas of my county. But then, as we've been going back and forth, there's still the conversation about the guardrails that are imposed, not just unique Vermont guardrails, but Constitution guardrails regarding what we can do in terms of pre-trial detention for somebody who commits what in the eyes of the law are not as serious offenses. The shoplifting offense, yes, it's bad and it shouldn't happen. Obviously, though, not nearly as bad as an aggravated assault for which you can be held in pre-trial detention. And so it's worthy of conversation and trying to explore what we can do that is constitutional, and having those conversations, I think, is how we move forward with this. I also just want to make sure to note that there are a lot of other aspects that can improve public safety, in my opinion, beyond just looking at bail revocation. And I don't want to speak for anybody else, but we have often heard about swift resolutions for cases. I mean, if somebody is on conditions of release for 3 years, waiting for their trial, that's 3 years of just occasionally showing up to court for a pretrial conference and, no other supervision except the conditions of release, which don't quite do much. So that's the long way of saying addressing the backlog. I feel is also one of the most important steps in improving public safety. But so did you ever respond?
Well, and I share, your concerns. I obviously have enormous respect for not just the constitutional limits, but the rights of defendants, their liberty interests.
Then Brian doing it otherwise.
No, I know you were, but I kind of want to reiterate that I take a balanced approach towards this as well, of kind of trying to troubleshoot the best possible solution. But nonetheless, there does, from our perspective in these Monday meetings that we have, it's what's the case this week, and it persists and persists. And, I do think there's, as I was alluding to last time we spoke, a huge value in reducing that court backlog. I mean, that's the huge push here. But reducing that from 3 years to 1 year would be enormous. But the question is, what do you do that day or that week when that person has committed the 35th crime? And they're released again and committing another crime that day. Going from 3 years to 12 months doesn't necessarily solve that. So that's kind of one of the things out there that, again, I think is a worthwhile policy discussion. But it's just a discussion that's kind of being broached just these first few weeks, and hopefully there's more discussion on the future.
There shall be. Thank you. Committee, we have, I want to say 5 minutes or so just to try to pivot into what general direction we want to take and what policies we've heard presented to us that we want to put into, I guess, a committee bill that can, these policies obviously can go in and out of such a bill. We can add to it as we see fit. But any initial takes on how to move forward?
I like the idea of the committee bill. There's several different segments within this omnibus bill that I'm very interested about. I don't think we can discuss that in the 5 minutes that we've been allotted after taking an hour and a half testimony here. But we're certain, I like the, when it comes to do the governor's warrants, I like that portion after having dealt with that on many different times. I'd like to entertain that one. The PIPs, those have to be addressed, obviously. I know there's many other areas that need to be addressed in that particular section, but there'll be some pros and cons as we go through that. But I'm very interested in the committee bill. Yes. Okay.
Senator Mattis.
Yeah, I agree. I just need to learn more about each of the different factors that go into this bill on whether it be bail or the warrant or the PIPs. Just gonna learn more about them.
Is there anything specifically that you don't want to see in the committee bill? Or that you do want to see in there, priority, or just generally?
I don't think I have the knowledge to know, to be
Yeah.
honest with you.
Senator Vogelstein?
I mean, I'm sure it'll probably come as no surprise that there's not a whole lot in there that I'm super supportive of, as it sits in the bill, which doesn't mean that there isn't conversation to be had. I'm certainly interested in seeing what's in the budget for community, substance use support. It's been an underfunded system. I think that staffing is an issue in part due to funding. That are often very low paid, high stress jobs. And so that is a piece that I think I'm open to exploring more. I don't know enough about the warrants, so that may also be a piece I'm open to exploring, because I just don't know, and I certainly respect Bob's on the ground experience with that, so I definitely want to learn more about that, but I have concerns with bail, I have concerns with telling the judiciary what they can and can't do, so.
And I might add, not to interrupt you, but just taking one step back further, I know that Senator Volsky has concerns about bails, and I too have concerns about bails, but I'd like to see us move forward with the revocation portion of that, or at least talk about that during the creation of our committee bill.
Yeah, my thought is to put together a bill. I mean, I also hold concern with how some of the language is written for some of these policies. I hold some of the concerns that Ledge Council raised as well. There are other pieces in this that I do like, just on their face, such as the warrants and the PIPs. One other section. It doesn't matter right now, but so I think that the idea would be to move forward with a committee bill, basically everything from section 12 moving forward. I believe there's already a draft that is being sent to the House. If we can just get a copy of that. And then we can have the conversation about bail revocation. And, the more we hear from the judiciary and Ledge Council about whether or not there's feasibility to it that are within the constitutional guardrails, that'll be useful for the conversation. And if we find out that it's a huge liability for being sued, then take it there.
Well, having said that, this committee in years past always considers constitutional guidelines, but continually just says, well, okay, we're going to go to court, we're going to get a challenge, let's get a challenge, so on and so forth. So, and that goes from everything from Bruin decisions to whatever else. Everyone just says, well, let's check it out in court, let them make the decision on it. So I think that should be a consideration, but not necessarily the template that we use, because we've stepped over that more than once here.
Yeah. Yeah, and there have been times where there are things that are clear cut constitutional violations and things that are a little murky, and things where there's no precedent, but only threats of litigation. So there's a wide range of issues when it comes to that. So, anyways, Senator Hosen.
Yeah, I'll have to look at sections 12 through the end of the bill to see if I'm comfortable putting my name on the bill with everything that is in there included, because I am doubtful that that will be the case. One of the things I have concern about is, we did some things last year to try to respond to the repeat offenders, and those haven't even been implemented yet. So I'm really hesitant to take additional action before we've even seen if what we did last year is working.
Yeah, and on that note, I mean, you also had the 4 judges recently start, and I mean, they'll be officially starting. They're wrapping up their training, I think, within the next week or 2. So that's also going to have a significant impact. Any additional thoughts? Okay, all right, we can adjourn that.